with that, I would like to introduce our next speaker, who is my colleague, Director Ashely Guritza. Ashely is the Director of the Office of International Collaboration and Export Control at the University of Central Florida and is also a member of UCF's Institutional Review Board. Ashely has over 10 years of experience advising higher education institutions in multiple areas of compliance, including export control, foreign influence, human subjects research, and contract negotiation. Prior to joining UCF, Ashely was the Associate General Counsel for the University of Wyoming. Ashely is admitted to practice law in the federal court system and both the federal court system and the state of Wyoming. And with that, let's welcome Ashely, who is going to talk to us about two very key topics: export control and foreign influence. Welcome.
Hello.
Ashely.
All right, to make sure before I lose you, can you see my PowerPoint? Am I good to go on the screen?
I can see your PowerPoint. I can see you. I can hear you. Go.
All right, wonderful. Hello, everyone. I would say good morning or good afternoon, but I don't know where you're located, so I'm going to say hello for us here in Florida. Thank you for joining me for an export control discussion at 4 p.m. in the afternoon. This should be fun and lively. I'm going to skip. Oh, maybe. There we go. Before I jump in, I want to be respectful of your time. So I have asked for us to do a poll to get an understanding of where you all are at in your export control expertise. So if I could go ahead and have you guys do that. I think I have to yell at Jennifer or Jane. I'll give you a couple minutes here. All right, that gives us about, okay, about 60% of people responded. And it looks like most of the folks in here have 0 to 5 years of experience, which is good. That means that the presentation shouldn't be boring to you, but I wanted to make sure to ask the question before we jump in. So I'm going to structure this a bit differently than I have my past presentations for FRAC. Usually I give you an overview of the law. Let me stop sharing that. Usually I give you an overview of the law and then I give you the updates at the end, almost like a carrot to continue to pay attention to this lovely export control discussion. But because of the way sort of the law has evolved over the last year and the intertwining you're seeing between export control and foreign influence, and we'll talk about that, what that is, I'm going to give you an overview of the export control laws, tell you the updates specifically related to export control, some of the updates, not all of them, and then give you an overview of foreign influence and talk about the updates that we've seen over the year related to that and the intertwining between the two different topics and programs. At the end, I'll give you a quick high-level summary, kind of key takeaways, and then open up the floor for questions. Feel free to bombard me with questions at the end. Happy to take them, and if I don't get through them all, feel free to contact me directly. You will see throughout my presentation this sunrise. I actually took this picture, and I'll let you in on a little hint. About less than 15 miles from where this picture was taken, I saw my first 10-foot white shark a couple weeks ago. The whole point of including the sunrise is I'm going to throw a lot of information at you. When you see this sunrise on a slide, that means that's key information I want you to take away. So if you don't remember anything from this, maybe you'll go, all right, I remember that curly-haired girl talking about that sunrise and that shark. I know those are slides I need to pay attention to. So keep a lookout for that sunrise. We're going to go ahead and jump in. From a broad picture perspective, export controls are laws and regulations that govern the export of certain commodities or information because there's some reason to protect that information or that item or that commodity for national security reasons. Maybe it's to protect trade, maybe it's a military technology, but that's really from a high level what it is. Generally, you have a very decentralized structure when it comes to the US export control regulations. You have multiple agencies like you see here on your screen governing those regulations. And depending on which agency is involved and which regulation is involved can impact the level of control on the particular technology or information that you may want to share or the research you may want to conduct. Department of State is the one that enforces the international traffic and arms regulations, and we'll talk about generally what that means. Commerce enforces the export administration regulations. A lot of times people stop there and they don't realize that there are additional agencies that actually enforce regulations, particularly the New York Regulatory Commission and the Department of Energy regulations. Those can come into play if you're doing research related to nuclear reactors, nuclear materials, so those are important to keep in mind. You also have the Office of Foreign Asset Control regulations, which impact not just technology, but interactions with certain persons and countries, and we'll briefly touch on that as well. All right, so generally the ear controls your commercial technology that may have a military application, but is being used for dual use technology. So the computer I'm on today is controlled under the ear or the export administration regulations. The laser pointers you may use when you do a presentation, those can be controlled under the ear. A lot of the beakers, your day-to-day, what I'm going to call lab stuff, is controlled under the ear. International traffic and arms regulations, they're really interested in controlling your military technology. So weapons, certain lasers that are intended for a military application, certain military electronics would fall under the international traffic and arms regulations, or commonly referred to as the ITAR. Both regulations are focused on protecting intellectual property, national security, and furthering foreign policy interests. The reasons for control can range anything from anti-terrorism, you see that on the screen, military technology, or because of a sanction or embargo, which we'll talk about. Generally, there are going to be two lists that you would want to look at if you believe you are engaging in some type of military work or some type of export controlled work. And we'll talk about how you would be able to identify that in a higher education arena here in a moment. The first is going to be the ear. So you see this CCL word on here. That's the Commerce Control List. It's not like you're going to go on here and let's say I had a manufacturing company and it's Ashely LLC and I make a drone. Well, Ashely LLC isn't going to come up on the CCL. What you're going to have to look for on that Commerce Control List is the specifications of the specific technology or technical information you're working with. ITAR is going to control your military related items like I mentioned. Again, you're not going to identify companies on these lists. You're really looking to identify the specifics of the technology that you're either receiving or working on or generating. There's good news and bad news with the export control regulations. The good news is that you have physical export and deemed export when it comes into play with both the ITAR and the EAR. The bad news is they're defined slightly different depending on which regulation that you're under, and the Defense Service can come into play under the ITAR. So physical export generally means you're sending, transferring, or taking something outside the US. That is generally pretty easy for people to understand. You know, you're shipping some piece of technology. You're sharing some non-public technical information with someone who's located outside the US. While physical exports come up in higher education, they don't come up as much as deemed exports. Deemed export means you're disclosing some type of technical data, technology, or source code to a non-US person in the US or abroad, and that technical information is export controlled. We see this all the time in higher education if you are engaged in export control work. And that's where, in my opinion, your highest level of risk is. And when most of the time you're going to need export control licenses, that's where it's really usually going to be, is with the deemed export issues. Like I mentioned, Defense Service is another term that you will see under the ITAR, and that's really where you're providing some technical assistance training or defense service to a non-US person. That can come up related to your deemed export issue. It can also come up if you have a faculty member, for example, who is instructing a foreign military on certain techniques. That can also include a defense service. Another key concept before we jump into how you identify whether you maybe have export controlled work or highly controlled export technology on your campus is the definition of foreign person. Foreign person means anyone who's not a US citizen or permanent resident. So this means under the regulations, you can have permanent residents, or sometimes referred to as green card holders, working on technology without obtaining a US export control license. If they're not a permanent resident or a U.S. citizen, that would make them a foreign national. And depending on the export of the technology, they may have to have a license from the U.S. government before they can participate. Related to the deemed export issue that I talked about, that release of non-public technical information to a foreign national in the U.S. or abroad, you have to have a release. That's a really important key term. The release can occur in multiple ways, so visual or other inspection. So maybe you allow them to look at the equipment or that technology, and that releases some type of expertise to the foreign national. You share some information that's non-public via email or video chat. That has become extremely popular. It always was, but even more now in the pandemic. Or you take some other act that allows the information to be released. So if you're engaging in certain export controlled work and you have export controlled technology, there's information security standards that you have to meet when you share that information over certain platforms, such as encryption. If you fail to do that, that can open up the ability for someone who's not supposed to access that technology to be able to access that technology. There are certain things that the regulations do not apply to. So if the information is in the public domain, and I'm going to do this with caveat, legally, then the regulations do not apply. If the information is excluded under the fundamental research exception or exclusion, and we're going to talk about that, then the regulations do not apply. The regulations also don't apply to basic marketing descriptions that are out in the public domain or artistic non-technical publications. So you may see a theme here. If it's legally in the public, they're not looking to restrict the information. As I mentioned, in addition to the list that identifies certain technology that's controlled and having possible non-public technical data that's export controlled, you also have controls that are beyond the list. So OFAC is the main one, that Office of Foreign Asset Controls. They contain lists or embargoes that prohibit certain activities or engagements with individuals on those lists. They can prohibit certain engagements with entire countries. They can prohibit activities with certain entities, and they also can prohibit certain activities with individuals. It's very important to consider these lists when you're thinking about a defense service, because if you fail to check these lists, even if what you think you're doing is not highly export controlled, this can have a major impact related to partnering with certain countries, companies, and individuals. Along those lines, in Florida, we have the Florida Travel Act, which restricts the use of state funds when it comes to certain entities that the United States Department of State has designated as a sponsor of terrorism. So you really want to make sure that, separate from it being an export control issue, do you have a potential issue with the OFAC regulations because of the country, individual, or entity involved? Or do you have a potential issue because state funds are being used related to a particular country that we're not supposed to use those state funds on? And we'll talk about some techniques you can use to try to mitigate those risks. I like to put this in here because people make mistakes, and believe it or not, the federal government does realize that. So if you think the regulations have been violated, immediately notify the appropriate individuals at your institution. So depending on your institution, that can be the export control officer, your vice president for research, the office of general counsel, whoever would usually be involved in those types of disclosures. It's better to self-disclose than not say anything. Honest errors are acceptable, but what we've seen is that gross negligence is punishable, meaning if someone just chooses not to comply with the law or tries to conceal an export control regulations, generally that's when we see the really harsh penalties come down, whether it be criminal or civil. So I would encourage you that if you think you have a violation of the export control process, do a voluntary self-disclosure, whether it's to state or commerce. The process is not as painful as you may think, and in the long run, and it can actually be a very big mitigating factor when it comes to export control. So some quick updates before we really jump into how this impacts higher ed. My updates this year are focusing mainly on countries. First one's going to be China. This is nothing new, but we saw over the last year a ton of updates related to China, particularly when it comes to the military end user list and the denied entity list. So the military end user list is a relatively new list that's under the Department of Commerce that identifies certain entities that the U.S. Department of Commerce has said, yep, these are military end users that you would need to obtain a license to really partner with, engage in activities with these entities. You have seen an expansion of the restrictions on exports that would have been very minimal. So certain types of information technology that would have only been controlled to Cuba, Syria, North Korea, and in the Crimea region of the Ukraine, now are being controlled to certain entities in China because of military in-use and end-user concerns. Separate from that end-user list, you also have had an increase of Chinese entities being added to that entity list. So that goes back to those Office of Foreign Asset Control regulations I spoke about. You have seen, I mean, and these are just some examples, April, June, July, November, and it's not like one entity is being added to the denied entities list. It's multiple entities and groups being added to these entity lists. That's going to be an important thing to continue to watch over this year, because as I mentioned, generally when an entity is added to one of these lists, it can prohibit a lot of activities with that entity, particularly the exchange of technology that you may consider benign or not highly controlled would now be very problematic if it's with an entity that's on this list. Along those lines, as I mentioned, my other update is Russia. Again, not shocking, but generally in the past, we haven't seen this much of activity with these particular two countries and adding entities from these two countries to the denied entities list or military end user list. You're seeing very similar things that you were seeing with China, also with Russia. You have their entities being added to the military end user list. And I would argue not to the same extent as we've seen Chinese entities added, but you've also seen Russian entities added to those denied entity lists. The other thing, if you engage in ITAR controlled work, meaning you are engaged in that type of work where you have some type of military technology, the ITAR was just amended in March of 2021 to include Russia on the list of countries that is a policy of denial for licensing, meaning you could go through the whole process and they have a policy of denial unless you're able to meet a pretty high standard. That's a pretty big change that we would want to pay attention to coming out of last year. So again, I would say continue to monitor efforts related to China and Russia, because I don't see that sort of approach as changing anytime soon. Separate from that, many of you may recall that beginning in 2020, Bureau of Industry and Security, which is responsible for Department of Commerce and those EAR regulations I spoke about, those commercially available dual use, not the military stuff, they sought a lot of public comment related to what this is called emerging and foundational technologies. And some of those examples are on the screen, because what has been apparent is that the regulations haven't been really able to keep up with some of the technology that you see coming out. For example, 3D printing is one of the ones that I just find fascinating that we're trying to get our arms around. It's not saying that everything on this list is now going to be controlled at a high level on the export administration regulations. But what you're seeing is the government asking for feedback on, well, we know we got to control some of this because it's intended possible applications, but we don't want to lock down all of commercial available stuff related to, for example, artificial intelligence. I think we're going to continue to see changes to the export regulations related to emerging and foundational technologies like you see on the screen. And over the last year, we started to see those already. In October of 2021, you had Bureau of Industry and Security issue a final rule expanding controls on biotechnology, including software. That was a pretty interesting one. And if any of you have all been following this as well, you may have seen a lot of discussion related to the delayed implementation of new cybersecurity export controls that are supposed to be coming out. The original implementation was supposed to be a couple days ago, so January 19th of 2022. But Bureau of Industry and Security received so much feedback from industry that they've delayed the effective date related to these cybersecurity controls to March 7th of 2022. Again, that's not indicating that these controls are going away. It's just giving us all a little more time to get familiar with what's coming down the pipe related to these new controls. So it's been a really exciting year related to the changes in export control. I put this one in here because this is just interesting. Given my law background, if you paid at all attention to this, you may have seen the law cases and the arguments going back and forth on where 3D printed gun technology and software should fall. I just think it's a very interesting argument. Originally, it used to be on the ITAR, and now it has officially moved to the EAR. Just fascinating. If you have a passion for export control, I don't know that anybody does, but if you do, very interesting information to read about how something gets transferred from the ITAR to the EAR and sort of the factors that went in to make that decision. That took place in June of 2021. And again, this is just relating back to those emerging technology and sort of the changes we're seeing. 3D printed one, I think is going to be a popular one we continue to see throughout the next couple of years. Okay. So I told you all this information about deemed exports, physical exports, the different laws. But what I haven't really told you is how this may impact your day-to-day in a higher education institution. First, before we jump into too far, those entities that I mentioned, so the names of individuals who you can't partner with, the entities that you can't engage in certain activities with, countries that would be of concern, that is low-hanging fruit. If you are just getting an export control program, or you think you're going to start engaging in export control work, one of the biggest suggestions I have for you to consider is use screening software, or use visual compliance. It expedites, it's quick, it pulls information from all the different lists, it updates as new entities get added, so those Chinese entities and Russian entities that I was talking about. Back in the day, you used to have to flip through the Federal Register. Nowadays, with that visual compliance software, it does all that for you, and you just have to type in certain information to screen certain individuals, entities, and countries. I would highly encourage that. The other thing I would encourage you to do is identify areas of high risk at your institution and amend existing processes before developing new processes. If you can build your export control program into your existing policies and processes, and we'll talk about kind of how we've done that at UCF, that can really go a long way and make your program a little more effective. And if you can identify the areas of risk, that can also make you, maybe you don't have the most amount of resources, either in personnel or funds, that can help you identify where you should maybe focus your resources. And why these may seem silly to some, there are some publicly available resources that I think are actually very helpful. Department of Commerce and Bureau of Industry and Security has a YouTube page. So I like to fish. So if I get tired of watching fishing videos on YouTube, I can go check out the Bureau of Industry and Security. But all joking aside, if you're just starting your export control program, they have some great resources there related to how to determine the export classification of your technology, how to submit a license, lots of good information there. So separate from, getting visual compliance software to make sure you're not, I keep saying visual compliance, screening software to make sure you're not partnering with someone you shouldn't be, or sending stuff somewhere you shouldn't be. The other impact that we see with the export regulations is related to distance learning. It can really impact your ability to offer certain courses in certain countries, especially if it's a comprehensive embargo country, example, North Korea. It can also impact your ability to allow graduate students to participate and work remotely. We have seen some updates related to distance learning. So generally, you're permitted to offer online courses in most foreign countries. However, due to the embargo laws under those OFAC regulations, those Office of Foreign Asset and Control regulations, there are restrictions related to Cuba, Iran, North Korea, Syria, and that Crimea region of the Ukraine. One license that I know a lot of institutions are monitoring pretty closely is in August of 2021, you had OFAC issue this General License M that allows higher education institutions the ability to export certain graduate level education services and software to people in Iran. It is a limited license, so go read it because it's got some fine print on it. It was supposed to expire, and at the last minute, they did extend this license to September 1st of 2022. So for the folks who are not involved in this in the day in and day out, general license means you don't have to submit a specific license, go through an approval process to be able to do certain things. The general license says, look, we're giving you the authority as long as you document and meet the requirements outlined in this memo that tells you what you have to meet to be able to utilize a general license. Something to continue to watch, especially with that September 1st deadline coming up probably quicker than we all realize. So separate from, screening individuals and entities and countries and the impact on distance learning, you also have the major impact on research, meaning the export control regulations can really impact your ability to share technical data. It can impact your ability to ship items to individuals and certain destinations. It can impact your ability to allow foreign nationals to engage in work, or maybe you have to meet some additional requirements before foreign nationals can engage in work. Can also impact international collaborations. You see talent programs on there. We'll talk a little bit about that once we get to foreign influence. Can impact your ability to publish certain research, which can be extremely important if you have a doctoral student or, a graduate student working on their dissertation who's not going to be able to publish because they've engaged in work on a restricted project and the information can't be released to the public. Important things to keep in mind. It can also impact how you dispose of property. You don't want to take something that's considered military technology and just throw it in the trash for anybody to kind of access. That would be extremely problematic. Can also impact the ability to engage in international travel. So all important things to think about if you're engaged in export controlled work, or if you're thinking about it. I mentioned that there's a big exception for higher education, which is known as the fundamental research exception. What this generally says is that research in science, engineering, mathematics, where you intend to publish the research or share it broadly with the research community, and the researchers have not accepted restrictions for proprietary or national security reasons, is not considered export control. Some key things there, right? That means the individual has to intend to publish. That also means that that individual, we can't accept an agreement where it says you cannot publish your research results, or you can only publish your research results if we approve the publication of your research results, or your research results are subject to a confidentiality agreement. Those would be the type of restrictions that would negate the fundamental research exception. So it's really important when you're looking at these research contracts to keep that in mind and make sure you don't accept some type of restriction that's really going to impact your ability to publish and do the things that your researcher may want to do. Or if you do accept it, have a plan on how to comply with what you're accepting, which we'll talk about. The key with fundamental research is it just applies to your research results. It does not apply to shipping stuff outside the US. It does not apply if you're going to engage with an embargoed country like we spoke about. Doesn't apply if you are going to try to engage with somebody who's on one of those lists, or a person who's, or an entity that's on one of those lists. Those would all be very problematic activities. It also doesn't apply to hardware. So it's really just the research results. So it can sometimes be a little narrower than people realize, and it's important to keep in mind that fundamental research is not a get out of jail, do whatever you want free card. It's really limited to the research results. Okay, so for someone who's just starting out in export control and thinking, holy cow, how am I supposed to get my arms around this besides having, screening? All right, I get that, Ashley. How am I supposed to identify whether we potentially need to care about export control? The easiest way I think about it is this sort of step process you see on the screen. First one is going to be, is there something about the activity that's unallowable by law? Is it an embargoed country? Is it somebody who's on a list? If the answer is no to that, then you go to, all right, input, conduct, output. My export team at UCF is probably tired of hearing me say this. Input, conduct, output. But really, when you have a highly technical issue, or if you're trying to get your arms around something, that is where I would recommend you start. Meaning input, what are you receiving? If from a sponsor, what are you procuring through the procurement process? Conduct, what are you doing? Are you generating something that's not public? Are you working with technology that you've been informed by the manufacturer that's highly export controlled? Output, what's the output of this? Is this being specially designed for a military application? Are you intending to publish your research results? If you do that analysis and you go, okay, there's something about this that's either military technology or not public, then you need to identify the list that it's on. Is it on the Commerce Control list? Is it on the munitions list? Is it on one of those Department of Energy lists? That's the analysis you want to walk through. After you walk through that analysis, that's how you identify what you want to lock down. You don't want to lock down a whole project if you don't need to. If it's just you're getting, if only one input coming in the door is some background information from a sponsor that only needs to be shared with the PI and with no one else, but everything else about the project qualifies as fundamental research, you don't want to lock down that whole project. You just want to lock down the input. On the flip side, if you're not getting anything from the sponsor, but your PI is generating some specially designed military technology and he's going to produce some widget that's going to be incorporated into a military drone, well, now you got to worry about the conduct and output. So slowing down and really going through that analysis is key to make sure you don't over lock down a project or a piece of equipment, or that you don't under lock down a project or a piece of equipment. So input, conduct, output, that is a very key phrase to keep in mind. So if at the end of the day you do accept export controlled work, what that really means is there may be some implementation of some security protocols you need to put in place. A technology control plan is generally what that's called. I would encourage you to make that a negotiation with your faculty member within the constraints of the law. Meaning, don't go in and mandate here's our template, here's what has to be used every time. Really sit down with them, get a feel for their lab, and help them come up with a solution that is both compliant, but also works for what they're doing. Or if it's just a piece of technology, help them understand, okay, here's how we got to protect that piece of technology. Can also mean additional US government oversight or prior US government approval, meaning an export license. Maybe you have a faculty member who really wants to ship that technology to somewhere that requires a license. Work with them to get a license. State and Commerce have really made it an attempt to try to automate that process as much as possible. It's generally kind of a step-by-step, walk you through a form with a manual. So don't be hesitant to go through that process to get an export control license. It can also mean at the end of the day that you have to say no, and you have to restrict international collaborations, travel, and foreign persons. That is a last resort for me. My team and I do not want to be the answer and no. We would rather do the customer service way and try to really help them do the research they can within the restraints of the law. And at the end of the day, sometimes faculty do not want to engage in export control work. And so what that can mean is, depending on the structure of your institution, your export control officer working with your contracts team or general counsel's office to negotiate those restrictions out of your research project to make the work not export controlled and publishable. A key thing I would encourage you to do is really know your research portfolio. This goes back to identifying the areas of risk. Partner with your visa teams. Understand who your foreign person employees are. Understand who your foreign person graduate students are and where they're at. Understand where your visiting scholars are coming in, and again, where they're at. And this isn't so you can go say, oh no, we got to watch these units because they're problematic. It's so you can go build relationships to where the first time they see your face is not when something goes wrong from an export control perspective. Go build those relationships, go to the dean council meeting, go to the chair meeting and say, hey, here's some issue, here are some risks with export control work. If you're going to engage in this, we may have to get a license before you can use any of your foreign nationals in the lab. Do that before they submit a proposal so that they don't get an awarded project and then they're like, great, I have nobody that can work on the project. It's really important to identify your risk areas and build those relationships to help mitigate those risks so you're not trying to do it when a situation arises. It can really foster compliance. If you're going to submit export control licenses to the U.S. Department of State, you are required to be registered with the U.S. Department of State, and part of that registration requires you to know your United States munition list categories. So what categories on the ITAR, ITAR regulations are you working with? So that's also important for you to know because that can help identify your risk areas. This one is also important. Don't just write a policy and put a TCP in place and not come back to it. That is problematic. Make sure you review and monitor your technology control plans. Make sure you establish a time frame on how often to review and use templates. Templates can become outdated. They're a useful tool, but you want to make sure you update those templates. Simplify processes. This is important. What used to work maybe 5 years ago doesn't necessarily work nowadays. Again, I can't harp enough on assess risk and obtain input from upper management. And I would say also obtain input from others that are involved in your processes related to export control. It's very important to keep metrics so you understand how how well your export control process is functioning, where delays are, where gaps are that could help improve your processes, how this is impacting your other partners, maybe in research administration, how this is impacting your faculty. So it's really important to make sure you audit or go back and look at processes that you've established to continue making your program the best that it can be. That's my high-level overview of export control. Now I'm going to jump you into foreign influence if that wasn't fun enough. So on the screen, you see the term inappropriate foreign influence. And the reason why that term is there is for a couple of reasons. First, at this time, there is not one unified definition of foreign influence across federal agencies and state agencies, and that's important to keep in mind. In addition, not all foreign influence is negative. International activities and partnerships are a valued and key part of the academic experience. So while you may see the term foreign influence thrown around a lot of times, what they really mean is improper or inappropriate foreign influence. That is what the concern is. You've already had the U.S. government and the government of Florida express concerns related to inappropriate foreign influence. And you've also had the Florida State Legislature, and we'll talk about that, express concerns related to inappropriate foreign influence. Without one key unified definition across the federal agencies and state agencies at this time, it's really important to know to kind of look for the key concerns related to inappropriate foreign influence. If you read the guidance or federal reports or even state reports, you can kind of identify some key themes coming out of those reports. First, there's a concern of the failure of researchers to disclose support from outside activities or foreign organizations. So that's a concern, right? Someone's getting money from somewhere or engaging in outside activities that we are maybe not aware of through the conflict of interest process our federal government isn't aware of through the disclosure process related to proposals. There's also the concern of unlawfully sharing non-public information by researchers. So sharing public, export controlled technical data unlawfully, that is a concern. If you don't know how to identify export controlled data or identify your risks related to your high risk areas, you could be making yourself a little vulnerable related to that, potential unlawful sharing of information if you haven't educated those researchers on, hey, this can't be shared. Unlawful sharing of US IP data or unpublished research results. You also have a concern, I'm not going to go through every one of these on the slide. You also have a concern about agreements with foreign entities that impose obligations on researchers that are contrary to university policies or federal state laws and regulations. Based on publicly available information, we've seen that with some of the talent programs. So where you sign an agreement saying you're going to give us all your IP, even though that may conflict with what you've agreed to at your university, or you say you're not going to disclose that you're part of this program, even though you're supposed to disclose that to your university. That's the type of concern there. Then you also have the inappropriate influence concerns related to data security and cyber attack vulnerabilities. The interesting thing with foreign influence is it doesn't just impact export control technology or research. It impacts student engagement. It impacts intellectual property. It can impact memorandums of understanding, your agreements to agree that you thought, really didn't mean a whole lot, but now maybe leaning towards some kind of concerns related to inappropriate foreign influence. So it is very far reaching when you consider how many tentacles could be out there related to concerns related to inappropriate foreign influence. We've all seen the news stories, but this can help you understand as well. You have the Harvard University professor case related to Charles Libra and potentially taking all this money from the Chinese government related to a talent program. A little closer to home for us in Florida, you had a number of individuals resign over concerns related to this Moffitt cancer center situation related to the 1,000 Talents program and funds that they were receiving. None of us want to be this story. And why I say it touches many sections of, your university setting potentially, it really intersects with export control. And the reason for that being is that export control protects a certain type of technology, particularly your military technology, and foreign influence access to that is very concerning. I'm not saying it's not concerning in other areas, but that's why you're seeing this intersection between the export control laws and foreign influence. And I think that's further supported because you're seeing a changing role at many higher education institutions where they're merging their export control and foreign influence programs. The reason for that is because faculty, campus in general, I'll even say campus in general, it can be helpful if they have one person to go to for answers or one location to go to get the information they need. So a lot of the individuals in the export control world have overlapping capabilities and backgrounds that can assist with mitigating certain inappropriate foreign influence issues. Again, this is something I don't see going away. I think you'll consider to see these merging of the foreign influence programs, inappropriate foreign influence programs, and export control. And I think the military technology in particular that's export controlled will continue to be a focus. So really, what does that mean? At the end of the day, at the federal level, here's what we're able to take away. Yeah, researchers are required to disclose support. Where we're at today, I would say really depends on the particular agency. Right now, to identify disclosure requirements, you got to look at the funding opportunity, the funding announcement, the funding notice, the agency guidebook, the award terms and conditions. That's all where you really need to look to kind of have a better understanding of what needs to be disclosed. You have agencies that have come out with some type of policy or regulation to assist. These are some of them that are on the screen: DOD, DOE, NASA, NIH, and SF. It's not going away. I do think there's some light, hopefully, at the end of the tunnel. Many of you may have seen that you had this National Science and Technology Council guidance document come out in January of 2022. This is very interesting for multiple reasons. If you haven't read it, it is a short read. It's about 30-some pages, but it really is a short read. What you see them focusing on is disclosure requirements and standardization, this digital persistent identifier, consequences for violation and disclosure requirements, information sharing, and I think this even goes back to what I was saying about the export control program intertwining with foreign influence, research security program mandates. So they're requiring you to have certain foreign travel security policies, research security training, and export control training. From my perspective, one of the things that I have the biggest takeaway related to that guidance document is for the first time you see an effort by the federal government to come up with a standardized definition of foreign government sponsored talent recruitment programs. And I think this ties in heavily with inappropriate foreign influence. I look to see agencies, again, this is a guidance document, but I think it's likely we're going to see agencies start to go towards this particular definition, and anything we can do to kind of get that standardization across the agencies will be helpful in us, explaining to our faculty members and researchers exactly what they have to disclose and how to disclose it. But I do encourage you, I'm not going to read through this definition on the screen, but it's very exciting to see them coming up with hopefully a centralized definition that could be implemented across multiple agencies. If you are in the state of Florida, you are probably also aware, and if you're not at this time, of 2 regulations that also intertwine with inappropriate foreign influence. First, you have that Florida State Statute 10-12-977 that was enacted in July 1st, 2020, related to conflict of interest and conflict of commitment. Really, what that impacted us is we had to make modifications to our conflict of interest disclosure process to meet a number of those requirements. This goes back to making sure you build those relationships with your faculty. We made sure to let them have input in that process related to those requirements. And then this last year, we had the Florida Foreign Influence Act that was enacted on July 1st, 2021. It is meant to address inappropriate foreign influence and has impacted a number of processes at UCF. It requires us to designate a research integrity office. We have to pre-approve all international travel by researchers. We have to screen certain individuals before they can be hired in research and research-related support positions. We have to make annual reports to the Board of Governors related to foreign gifts and donations. And then intertwined in those requirements I just articulated are other documentation and related reporting requirements. So you're not seeing this go away. I think it's only going to continue to come our way. My recommendations related to the 2 programs are you unify across upper management, use existing systems like I mentioned, inform the university community to the extent you can. We have developed a website to assist with inappropriate foreign influence. You can't really standardize it too much if we don't have standard definitions across multiple agencies, but I think the further we go that direction, the more we can do to educate campus. Go out to the meetings, go out to units, even if it's virtually, will go a long way. Don't be afraid to amend existing processes rather than putting more processes in place. But we do understand, to the extent you do develop a new process, we did implement a new foreign influence assessment process that ties into multiple processes at UCF, just because we were looking for one centralized way to the extent we could make it centralized to kind of help mitigate the risks associated with foreign influence. So here's a high-level overview of what the foreign influence process looks like at UCF. Really, what you see here is all the departments we train, the main activities that we're screening in some sort of fashion, who we partner with. And at the end of the day, we're looking for red flags, whether it's an export control red flag or a foreign influence red flag, helping to either mitigate that red flag, get the appropriate approvals to be able to do whatever the faculty member or researcher would like to do. But the more you can centralize your efforts, I think the more successful your compliance programs can be. And like I said, I can't harp enough on making sure you get buy-in from your other supporters in research administration and your faculty, because you don't know what you don't know. And while something may look great on paper, you go to try to implement it at your institution, it may not quite work as well as you originally thought. I will also say one size doesn't fit all. It's really important to know your research portfolio, know what your institution's like before you maybe try to implement something exactly like UCF did. It really kind of depends on your risk area and then the different activities you're engaging in. I have to put this in here. I don't, but I think it would do you a disservice not. With export control, there are significant penalties, both civil and criminal, and not just for the higher education institution, but also for the individual. You also can have severe penalties related to foreign influence. You know, you can have investigation costs, debarment, incarceration. I mean, these are really sad. But the other thing that's important to focus on is there's an increased focus on higher education institutions right now. And if there was ever a time to make sure you have a good export control and process and ways to mitigate inappropriate foreign influence, this may be the time to do it. So with that, I will stop talking and take a breath and open it up for any questions that you may have on either topic.
Okay, everybody, this is your chance. All burning questions. I know that for us, when we are flowing terms down for subawards, some of the unique Florida requirements, we are getting some pushback on that. So that's something that having a unified executive leadership is very important.
To Jennifer's point, that's a very good point. I would also say that's a really great point. For us in Florida, I know one thing we're doing related to our inappropriate foreign influence requirements is making sure to reach out to the other SUS schools to get a feel on how other institutions are doing what and how they're able to do it. Because you may have your institution may have a great idea related to one particular requirement, and they may have something you never even thought of. So again, yes, I completely agree. That's a support from upper management and knowing what your peer institutions are doing can be very helpful.
Absolutely. There's a question in here from Mary Beth. I've noticed a lot of the foreign influence cases have tanked, although they have been there have been 1 to 2 convictions. Any sense of the government backing off because of the court losses?
It's a good question, and we kind of been monitoring the same thing. I would say no, because you just had the conviction. I want to say it's Libra, and I hope I don't misspeak here. I want to say they did move forward with the Libra one. I am familiar that they've, dropped a number of the cases, and my understanding is it seems more from a procedure standpoint rather than we are no longer concerned about a foreign influence standpoint. So I don't see them backing off because of that. I'm thinking maybe they're just thinking, and this is my hypothetical, that the Department of Justice system is not the best way to try to tackle it initially. Rather, the better way is to institute these disclosure requirements when you're receiving certain federal funding and institute certain requirements by the states rather than trying to tackle it through the justice system. I could be way off on that, though.
Your guess is better than ours. Okay, and then Christina Corvo's asking, she said you already addressed this, but she's at a smaller community hospital, and she's wondering how you assess when your research program needs an export control program.
Yeah, so that I would argue you need some form of an export control program in some form of fashion. That doesn't mean you need an entire export control office. Coming from my prior institution, I built the program there. And what we did to determine whether we needed, to extent we needed that program, we really first made a determination whether we were going to engage in restricted research. So are you going to have the direction of accepting restrictions that don't allow you to publish? Or are you going to engage in some type of military development? Being at a hospital, I kind of think the answer might be no to that second question, but who knows? If the answer to that question is no, then the risk kind of change that you're trying to mitigate, meaning you're more focused on who your vendors are, who you're partnering with, and that's where you'd maybe want to put more resources towards visual compliance screening software. That is kind of where we started is, all right, are we going to accept the restricted research or not? If not, like I said, you would lean towards the screening software. If yes, then I would say, okay, what are the units that are most likely going to engage in that restricted research or technology development, begin the education related to that. That's where I would kind of start my analysis.
Okay. And then Michelle Benson asks, would you be able to provide, it's scrolling up. Would you be able to provide some details
Yes.
on how you implemented review workflows with your partners at the institution. For example, do you review all contracts, or does the contract team have a set of red flags? I'm just so proud of how we do that. So I'm going to stop asking the question and let you start answering it.
Yes. So I do have details, and I've done it different ways at different institutions. So at UCF, we have a wonderful contracts team, and we are such a large enough institution where not only does our contracts team look for red flags, we have actually implemented a process at the proposal level to look for those export control red flags. Reason being is we actually do engage in restricted research where we submit licenses to both Department of Commerce and Department of State throughout the year. And anything we can do to get those licenses for the faculty member and their research team before we even get notified of the award goes a long way and doesn't hold up their research. So yes, at UCF, we've implemented those red flag checks at the proposal level and at the contract level. We have also delegated RPS searches. We've delegated RPS search capabilities to both our research foundation and our UCF foundation related to donating, like donors coming in and gifts. We also have it done on our foreign partners for both proposals and contracts. We also have it implemented through our conflict of interest and commitment process. We also, I'm trying to think of all the different ways. We haven't implemented it in a number of areas, but they do have to, before we allow folks to engage in that red flag review or use RPS searches, they have to go through a training with us to make sure they know what they're looking for and how to use the software. Not that it's that difficult necessarily, but we want to make sure we're consistent in our approach. At my previous institution, I was a one-stop shop where I did all the contract reviews for export control. I was the only person who did RPS searches, but that's because our research portfolio was very different and we were a much smaller institution.
Okay. And Courtright, Courtright and Nicole are really sort of asking the same question. Is everybody responsible for sending it over to you, or is there just one area and we're all responsible? I mean, as you were just saying, you know, wherever it's identified that there's a potential, it's at that area that we want to make sure that we get your group engaged. At least that's the way I believe that's the way we're doing it. That's what our intention is. Is that what you're finding? Are you getting it from different areas?
Yeah, so that's a good question. That is correct. Generally, we're all responsible because my team can't be everywhere at one time. However, I don't know if this is where you're headed, but yes, we partner with our units to identify those red flags. But we also have measures behind the scenes to catch things that may fall through the cracks. People make mistakes, or sometimes training doesn't sink in, or sometimes there's a gap in training. So we do have measures built in, whether it's on the inappropriate foreign influence side or on the export control side, where my team does have ways to identify things that maybe should have come our way and didn't. And then we work to resolve those things. You know, knock on wood, our hope is always the resolution is, okay, hey, this should have came our way, but it's not export controlled. If it should have came our way and is export controlled, then we have to go down the process of, do we have a voluntary self-disclosure we need to make to the US government? So I guess you could kind of say we're the gatekeepers, but we really are partnering with a number of units in research administration to make our process as effective as it has been.
And I think the point that you made earlier about how important self-disclosure is, I think that if you show that you realize you had a mistake, had a gap, whatever, that goes a lot further than to try to cover it up or act like you didn't know you'd made a mistake. So
yes,
self-disclosure is golden.
It has been absolutely key. You know, I know, even when the federal partners come to meet with you, don't be nervous. As long as you've been truthful in that self-disclosure, a lot of times they're like, okay, you're telling me here's what happened, here's what you did to correct the situation, and here's why it happened. Correct? Yes. All right. You know, knock on wood, generally, anytime we've made a self-disclosure, there's not been any repercussions because we've been able to show either what failed and how we improved it, or they're like, okay, that was a little bit outside your ability to stop.
Okay. Serena Blackwell's asking, looking for more clarification, who exactly checks at the proposal level? Do proposals route through export control first in your proposal or contract system?
Yep. So it's our proposal managers, our proposal groups. They review the proposal at the time of submission. And right now they complete what's called this export control assessment form for red flags. That's something I'm hoping down the road, sooner rather than later, we can automate in our research system. We have Huron. My hope is somewhere down the road, we can get rid of that form and automate it, because that's something I think we could improve on. They do the review at the time of submission, and then through our research system, the proposals are routed to the export control team for review. We do a preliminary, if sometimes you're able to make an export control determination at the proposal stage, other times you're not. So if we're able to make the decision, we let them know and say, assuming there's no restrictions in the award or the contract, this isn't export controlled, or this is going to be export controlled. The contract needs to come our way for review. When the contract comes in as part of the contract negotiation, our contract team knows to look for those red flags and see, one, if export control was looped in at the proposal stage. If so, what was our decision? Are there new things there that weren't there at the proposal stage? And then they would re-loop us in at the contract negotiation stage.
Okay, and then we've got another, can you talk about how you, about online solutions you use to keep up with the various export control rules and lists, visual compliance, et cetera?
Yes, so visual compliance is one we use. From an industry perspective, Jim Bartlett has a wonderful newsletter that I rely on a lot, because he's coming at it just not from an academic perspective. So if you're interested in that, feel free to reach out to me directly and I can forward you that. From a higher education perspective, you have AUECO for export control managers. That can be a good way to kind of stay on top of stuff as well. A lot of folks are always posting in there. And then honestly, I just take a time out of my week, whether it's with my Sunday coffee or, sometime on the weekend, if it's not going to be a good fishing day, and just take a look at what's going on out there in the news. That can be a good way to make sure you didn't miss anything. But generally, Jim Bartlett and AUECO has it covered. So those can be good resources. Visual compliance is helpful for screening. I don't necessarily rely on them for regulatory updates. I tend to get them quicker through those other two resources I just mentioned.
Okay, and I guess the question that may be burning on everyone's mind is, were additional, this is from Melissa Giglio, has UCF had to hire additional FTEs to review all that of that information centrally? And let me say, one of the things that's happened at UCF is that we've doubled our funding in a short amount of time, and doubled the number of awards and the types of awards. So that is definitely a factor here. So take it away, Ashely.
Yes. And so I will preface this with saying that my team is considered that research integrity office for the new Florida Influence Act. And so as a result of that, the scope of what my team was required to do expanded. So we were already in the process of getting another FTE for our export control team, but we really had to build the side of the house for our inappropriate foreign influence program to be able to meet the requirements of the Florida Foreign Influence Act. So we added an FTE on the export control side, and we have added 2 FTE on the inappropriate foreign influence side. I will tell you, the unfortunate thing is we've not been able to hire anybody on the export control side. So plug, if you know anybody interested in Central Florida with export control experience, tell them to submit an application.
Okay, you've got 266 candidates here still on the line.
If you ever dreamed of a career in export control, yeah.
Okay, well, thank you very much. And I think most of what we're getting now is just people telling the truth about what a wonderful presentation this was. And I want to thank you again. We will share any resources that Ashely shares with us. And Ashely, anything that you think would be helpful, please forward it along. We'll be sending it after the end of the conference. So because we're, there's just a few of us working on this whole conference. So thank you very much. And I look forward to hopefully seeing you present here at FRAC again next year. So
Thank you very much.
All right. Okay, folks. See you again